Our last case of the morning is Stefanski versus Saginaw County 911. Good morning. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive. Mr. Kelly, you have time that you may reserve for rebuttal. We ask that you keep track of that yourself if we do not use it up. And you may begin when you're ready.
Thank you, Your Honors. May it please the Court, Kevin Kelly on behalf of the appellant, or the appellant. This appeal raises a question I think we could have plucked from a Socratic dialogue. What is law? And while hopefully we can all see some humor in the fact that we're a bunch of lawyers arguing about something so simple as what a law is, it does raise serious issues about compliance with the law, the use of the rules of statutory construction, the respect for precedent. Because that's, I believe, with the arguments and what has the procedural posture of this case really is showing a disrespect for the rule of law. While appellee and amici propose application of using various tools, interpretive tools, neither confront the fact that this court has held multiple times that the language is clear and unambiguous. No party has advocated that this court overturn that past precedent. It just ignores it and asks this court to ignore it. And that's violent to the rule of law. And maybe there might be an argument to overturn those cases, but it's not our job or the court's job to try to develop those arguments for one of the parties. Where the statutory language is plain and unambiguous, we apply it as written. There's no room for further judicial construction. So the question really becomes, okay, what does the plain language provide? An employee is protected if the employee reports an actual or suspected violation of a law. That term is undefined. So what do the rules of this court and the opinions that have been held down, the law of this land say? Well, we first turn to dictionaries. And here, I don't think it really matters whether you use a lay or legal dictionary because the definitions are pretty much the same. And the suggestion, I think, that's implied in the amici brief that, my arguments or something or suggestion you should be potted plants, that's not what the case. We should be looking at multiple definitions. We should be trying to figure out what the sense of and different senses of this word is. But if you look at that, the most common definition is some type of aggregate or the totality of the rules, standards, adopted by the government, whether that's the executive, legislative, or judicial branch.
So, counsel, here there's some weight in the defendant's brief on the question that it's a law, not law. What difference does that make, if any, in your opinion?
I don't think it makes any difference because it's a matter of semantics, right? Am I claiming that Mr. Stefanski reported every principle of the common law to the public body? No. It's a principle, right? The principle that says governmental employees cannot engage in gross negligence.
Well, let me stop you there because you just said it was a principle of law. And I'm struggling with gross negligence is a legal standard. It's a principle under the law. Is it a law? What law was violated by allegedly acting grossly negligent? Well,
where does the principle come from? Right? It comes from various court opinions saying this or that is act of gross negligence, from court cases saying this is what gross negligence is.
Well, sure. Gross negligence could be conduct that exempts a public employee from civil liability for operation of a vehicle, or the municipality for owning a vehicle because of gross negligence, or an intentional tort. I mean, so it's a standard that exempts them from liability
That's
or
a
exempts them
statute.
from the exception to liability. It's also a criminal standard in some contexts, right, where you could be subject to criminal liability for that. It's a standard. I don't understand how gross negligence is a law that is either violated or suspected to have been violated.
And I'll layer on that, because I have the same question. It's, you said it's, unlawful for somebody to be grossly negligent. I'm like, I'm not sure that's right. The law says that you can get sued civilly for being grossly negligent.
Well, you could be grossly negligent and not cause anybody any harm. You could do something that doesn't involve any of the things, like that law regulates you for not being grossly negligent in doing that. Just gross negligence in general isn't against the law, is it?
Well, how is somebody
Like if
held
you were
liable for
alone
it
in
if
the
it's
woods
not-
and you were grossly negligent, are you violating the law?
How is somebody held liable if they're not violating the law?
Right, so there is
mean, how
there's
do
a
you get to
potential
that?
cause of action, I agree, but it's sort of like, it's now by extension now to, we're not talking about obviously the estate of, who was allegedly harmed here, who maybe could allege gross negligence against the county, but we're talking about an employee. So it's like one step removed from the way the gross negligence analysis would normally work.
Okay, but I think that gets to, how can you say then that the rules of court, which not only this court, but multiple courts, I mean, going back to England, have held that the common law is law. And so what is the common law, if not the principles and rules of the common law? I mean, are you going to say, well, did he violate this specific court case? No.
So
I mean,
is every time an employee goes to their boss to disagree with maybe a disciplinary decision or, something that was a mistake in the workplace, are we now in the world of that could be gross negligence? So if anything happens to that employee, they have whistleblower protection?
No, because I think you're taking it too far by sounding the alarm, because as pointed out by Justice Kavanaugh, why wouldn't those issues be handled on causation, right? The legislature wrote the statute as it is, so we have to deal with it as it is and what those implications are. And if the plain language, because common law, I mean, are people really going to argue that the common law is not law?
Well, say I agree with you that common law is the law, and it could be under and actionable then for somebody who reports a violation of the common law or suspected violation, say the common law misconduct in office,
Okay.
right? Why misconduct in office, common law fraud, common law, whatever. Why is being grossly negligent equivalent to that? Well, how is grossly negligent, like, even if, like, driving a vehicle in a grossly negligent fashion, that's against the law, that's defined by common law, so if an employee reports a co-employee doing that, perhaps, but why just grossly negligent?
Well, because in this case, it happens to be alleged gross negligence. I'd agree, any violation of the common law is a violation of the law. And I think, okay, that might include very petty, very frivolous complaints from employees. But we handle that on causation, because who in their right mind is going to care if somebody said, hey, I thought he was driving a little negligent. Well, nothing happened, nobody got hurt. Why would an employer retaliate against that person? They wouldn't. I mean, it wouldn't make sense. What's the difference here? This was a really big deal. A woman sat dying, screaming for help for over an hour and 25 minutes.
So what was the law he violated, or the employee violated?
He
in this
engaged
case?
in gross negligence in this particular case. And I mean, if you look at Landon, of course, not to bleed into the, that
So
case.
he
but-
could be sued and not be protected by governmental immunity because of the gross negligence? Is that what you're saying?
No, I'm saying, because whether somebody knows about governmental immunity or not, I don't know that matters for the case. What the issue is that here's a rule or principle of the common law. People cannot engage in gross negligence, right? I mean, I think that's a pretty straightforward proposition. Okay, if you report that somebody,
But you can engage in gross negligence. I mean, if I'm sitting alone in a padded room and I'm grossly negligent, I can do that, can I? I mean, doesn't my gross negligence have to be something recognized in the common law as violative of the law?
but
Meaning operating a vehicle, any other instance where it's been recognized. It's a standard of conduct by which people's actions are governed.
Right, but here, we do have all those elements that we could say that the whole thing where he was grossly negligent, that caused damages because a woman who would have been otherwise saved if she would have gotten appropriate medical care, and so you have that. And the analogy, I think, is although Landon, I think, is dealing with different statutes and stuff, what does the court do in that case? It looks at what are the elements of a medical malpractice case and finds that all those are satisfied here. Now,
Counselor, are you suggesting there's some sort of duty that this person was grossly negligent in undertaking? And if so, what is that duty or obligation?
well, once you are starting to process a 911 call, you have to do it without negligence. And the idea here is that somebody who has been shot and you're told that she says she's been shot and you don't send medical, and you let the person sit there for over an hour and 25 minutes and they die on your watch, I think that's grossly negligent. I think that is wanton and reckless disregard for the safety of the person. And once you picked up the phone and you started your undertaking that I am now going to assist this person, you have a duty to not do it in a non-negligent way. And there's
And that
cases.
duty is recognized in common law, or is that duty imposed by statute? Where does that duty come from?
One, in common law with the principles of...
Is there a case that says that? Is there?
Well, there's cases that define gross negligence. There's cases, I mean, I don't have a cite for you, but I can come up with cases that I'm familiar with where there's fact patterns where somebody is reported to 911, I forget what county, I think it was Wayne County, I don't know if it was a federal or state law case, but the facts are analogous that, you know, the guy was falling asleep at the call and missed the call. And the guy had a heart attack and died because no one picked up the call at 911. And so, was it grossly negligent when you have people's safety on, you know, your hands to fall asleep? Yeah. Was it grossly negligent here that you didn't send an ambulance when you know somebody's been shot? And even if you second guess it, you send them anyways because you know that they might be shot? Absolutely. But more importantly, even if it's not grossly negligent, which I would say to the day I die it is, that it's a suspected gross negligence, right? Does he have to get it right? Does Stefanski have to get it right that this is gross negligence? No.
So, okay, I think we're beating a dead horse, because I think the relevance is to the duty question. And maybe it is a duty recognized in common law, as you suggest. Gross negligence is the standard by which we evaluate whether that duty was breached, right? Mm-hmm. But sort of dialing back on this, the Court of Appeals never actually addressed this question of whether or not there was a report of a violation of the law, right? Because they said it can't be a violation of a law if it's only alleged to be common law.
Correct.
Right, so they never got into this. So it could be that, you know, this is something that gets lit. I think it was argued in front of the Court of Appeals, but it wasn't decided by the Court of Appeals, is that correct?
Correct.
Okay.
And I'd just like to get to, you know, some other points. I mean, if you look at, besides, you know, the fact that we've treated common law as law for hundreds of years, you look at the other statutes, and I cited in my brief, there's multiple times when the legislature wants to specify statutory law, they do so. They use the term statute or statutes, statute law, and all sorts of times, and they distinguish it in multiple statutes, MCL 2.5911, MCL 449.1402, MCL 5505244, all of those distinguish law from statute. And so if the legislature is using the term law in other contexts as broader than a statute, that there's been Michigan and federal and foreign case law that has interpreted similar provisions to include the common law, what is the argument against it? Either the principles and rules of common law are law or they're not. And I don't think this court is prepared to overturn decades, centuries, maybe a millennia of legal precedent that says common law is law. Because what else is it then, if it's not law? And why do I have to abide by what this court says? The buzzer's gonna ring, and I could keep talking.
I'll stop you.
Yeah, I know, but if I refuse, what authority? It's the inherent power of the courts. It's the court order to stop. Because if I don't, I'm sure very easily you could throw me in jail. Now, if that principle of common law, which says the courts have that inherent power, is not the law, what on earth basis would there be to lock me up? There wouldn't, because if it's not law, I don't have to follow it, right? You don't have to follow some agency's interpretation of this that hasn't gone through the rulemaking process. It's great, it's guidance, I don't have to abide by it, you don't have to abide by it. So if it's not law, what is it? And there hasn't been a definition that's been proposed that complies with our rules of construction, that you look to the dictionary. And just to briefly respond to the amici brief, I'm sorry, but average day people are not going to understand what quasi-legislative functions are. They haven't been to law school. I don't know if all lawyers have a great understanding of that, right? And so to be able to throw that there and just pick up a definition that they create out of thin air, this is not the rule of law, right? It's the rule of men and women deciding what they want to define these cases are, finding a way to rationalize it, and then going with it. That's not how we do it. We look to the case law, the dictionaries, we find the definition, and we apply it as written. And common law is law. Thank you.
Thank you.
Good morning. Good morning, Your Honors. Andrea Pike on behalf of Defendant Appellee, Saginaw County 911 Center Authority. Sorry about that. May it please the court, I am here on behalf of Saginaw County 911 for this Whistleblower Protection Act claim. As you know, we went at the trial court, we went at the Court of Appeals. The trial court granted summary disposition on the basis of both C8 and C10. And as was previously stated, the Court of Appeals only dealt with the legal issue of whether common law was protected under the Whistleblower Protection Act. So this court proposed two questions for the supplemental brief and for this mini oral argument, and that is a report of common law negligence or gross negligence a protected activity under the Whistleblower Protection Act? The short answer is no. Allegedly reporting a violation of common law, including negligence or gross negligence or even medical malpractice, is not a report of a violation or suspected violation of a law or rule or regulation promulgated pursuant to law of this state or law of the United States, and that's MCL 362 as interpreted by case law. The second question is if it is, did the trial court properly grant summary disposition to 911 authority? And the answer is yes. What was said by appellant to his supervisor, Director Weaver, did not amount to a report, and it did not amount to a violation or suspected violation of a law. Appellant did not engage in a protected activity. Based on his allegations in his complaint and his deposition testimony when he testified, his communications to his supervisor didn't amount to protected activity when you look at what he actually said to his supervisor. So his statements to his supervisor are very important to the court's analysis. The statute itself does not say common law, which has been discussed. But if it did, if the first part of MCL 15.362 is to replace law with common law, then technically it should be promulgated pursuant to common law, because it says promulgated pursuant to law. So you have law in there twice. It seems that appellant is only trying to switch out law with common law in one instance and not in both instances. So how do you promulgate a law, regulation, or rule pursuant to common law? And as this court pointed out, gross negligence is a cause of action typically. It's not the basis for reporting something that the employer can then look at and have objective notice that something occurred that they should look into, that they should investigate. What occurred was it was an employee complaining that a supervisor wasn't disciplined. He waited 3 weeks the first time he talked to his supervisor to complain, when he talked to the director of 911, to complain about a supervisor and why nothing was being done. And then in the second instance, because in this case he alleges he spoke to him 2 times, the second instance was August 16th, 6 weeks after the 911 call happened. The 911 call happened when he was not working. His shift started after the fact. His shift started when the victim was found, but it did not occur when the initial call came in. And so,
Why does that matter?
I'm sorry?
Why does that matter?
Because it matters when he said it and what he said. So he wasn't saying this law was violated and we need to fix it, or we need to go to the authorities, or let's call the FBI. He said, what happened with Logan? What's going to happen to Logan? Why is nothing being done? If it was me, I may be fired or disciplined, or I may go to training, but it's a supervisor, so I guess that's not going to happen. He was complaining and he was inquiring about a personnel matter. He wanted to know if his boss was going to be disciplined. That was the line of his inquiry. It wasn't to report, bring a hidden violation to light, give an employer objective notice, give a public body objective notice.
Because they were already on notice of what took place?
They were already on notice. Appellant testified that everybody was talking about it, including the bosses. So it wasn't like nobody knew this 911 call happened. Everybody knew it happened.
What part of the statute are you relying on to say that the notice has to be previously unknown?
Case law, Your Honor, not in the statutory language itself, but interpreted by case law. So in order to have the objective notice portion or requirement, I'm relying on Rivera, Rulstein, and Kaufman to say an employer is entitled to objective notice of a report or a threat to report by a whistleblower. And then further, the purpose of the Whistleblower Act is to protect the public by encouraging reporting of illegal activity. That was the Hayes Court from 2013. And then the Landon case, that was the basis for the Court of Appeals affirming the trial court decision. The Landon court said the Whistleblower Protection Act was enacted to encourage employees to assist law enforcement, protect those who engaged in whistleblowing activities. Here, there's nothing that was brand new. He didn't share details, accounts. So the Hayes Court, which is a published Court of Appeals decision from 2013, they said the plaintiff failed to establish she made a report under the Whistleblower Act because she was merely making an inquiry, not a report. They noted that there was a lack of specific detail, that there needed to be an account of an event or a situation. Again, we have an employee that wasn't even there for the event or situation. He claimed that he listened to it after the fact, and so he wanted to know what was going to happen to his supervisor, but he wasn't providing any information that would help with an actual investigation. It came up earlier with this court about gross negligence being a separate count, and maybe that being something that could be brought by the estate. There is a pending case brought by the estate that opposing counsel filed, and they have trial in April of this year. And that is a gross negligence count against not only my client, but the supervisor, Mr. Bissell. So that's a separate matter. And in this case, he's trying to say, okay, not only was this gross negligence what happened to the victim, but the employee that talked about it, that questioned things, that made an inquiry is now protected under the Whistleblower Act because he made a protected activity. We didn't get into causation. We didn't get into adverse action at either court level yet because the legal issue was whether or not there was a protected activity, and our answer was there was not. Two ways, because what he said wasn't protected, because he didn't point to a statute. He didn't point to something like a code. They talk about coding the call wrong. There's no Michigan, code book of how they have to code it. It's actually different per county. And the appellant testified that it's discretionary how they code it, and it's different per county. So it's not a black and white.
I have a question, though.
Yes.
I hear what you're saying, but it's discretionary. The person there's a distinction between shots fired and a person actually being shot. How is that discretionary? I think the notion that you would code something in such a way that it doesn't distinguish that, I think is concerning, right? One means send an ambulance, another means just send a police response.
So they both end up sending an ambulance. They are coded with the same amount of priority. And oftentimes as they gather more information, they'll change how things are coded. It was appellant that said it's a discretionary process. Sometimes we change it as we get more information from the 911 caller. In this situation, without going into too much detail, there were two people on the phone, and one person said, I don't know if she was shot.
I see.
And the delay in the ambulance had nothing to do with 911. It had to do with police presence. An ambulance will not go to a victim after a shooting, because there could be.
Counselor, so you're saying,
Yes.
when you say there's no protected activity, is your primary argument that there's no protective activity because it's something covered by common law and that's not in the statute? Or your argument is primarily there's no protected activity because of the facts of what happened here?
Both, Your Honor. So there were two legal issues before the court, and the first addresses that common law is not protected. Common law is not law as defined in the Whistleblower Protection Act.
And you would agree that the protection of the Whistleblower Protection Act extends beyond statutory law. So for example, if there's a violation of a constitutional provision, we would all recognize that as law, right? Or
Yes.
a law.
Yes, Your Honor.
And so Justice Kavanaugh raised the question of misconduct in office. So that's a common law offense. It's defined by elements. It's punishable as a felony. Would that be a law that could be reported under the Whistleblower Protection Act?
If it's in a statute.
It's not
or-
a statute. It's
Okay.
defined by case law, but it's clearly defined and punishable as a criminal offense.
Then it would not be included as a protected activity in the Whistleblower Protection Act. So there's no case law that applies common law as protected activity. All the cases, Landon and then 3 unpublished cases that came after talking about Landon, make it or state that medical malpractice, for example, is based on common law, and that is not a protected activity under the Whistleblower Protection Act. And then also the Muir case, I don't know if it's pronounced Muir or Meyer, that I cited that's unfortunately unpublished, talks about how common law is not a protected activity under the Whistleblower Protection Act, because where do you draw the line? It talks about breach of contract and other counts.
So we're
like-
trying to figure out how to draw the line. So what
Yes.
about case law that interprets the Constitution? So if there's a violation of Miranda and that's reported, that's not in the text of the Constitution. I think it's a pretty well-understood law. Would that be covered under the Whistleblower Protection Act?
So I guess it sort of depends. MCL 8.8 defines law as a legislative public act, law adopted by the people, executive order, Michigan compiled laws, or Michigan compiled laws added to statute or amended after publication. So I don't believe that would match that definition. I don't believe that that would be protected activity. A violation of the Constitution itself would, but something under that example or that hypothetical likely would not apply based on the case law. There is no case law that says, yes, common law is protected under the Whistleblower Protection Act. And so that's why my opposing counsel has gone to the dictionary to try to expand that definition, but there is no case that applies it. There's cases that don't apply it. If medical malpractice, where there's an actual duty, if medical malpractice is not a protected activity under the Whistleblower Protection Act, how can gross negligence be a protected activity under the Whistleblower Protection Act? And I haven't seen anything to the contrary. The Muir case, or Meyer, I'm not sure how you pronounce it, I apologize, talks about it would, if we were to expand the Whistleblower Protection Act to say, yes, it does include common law, it would cover not only negligence and gross negligence, but breach of contract, fraud, defamation, invasion of privacy. It would, I mean, where does it end? You know, there's always going to be an employee that disagrees with what another employee did or what a supervisor did, and maybe that they would have done it differently. Here, he says that he would have coded it differently, but he wasn't in that chair at that time coding calls. He wasn't working. So just because he disagreed with that, you know, so he's venting about his disagreement and he's inquiring. And I think that's a big deal with the Hayes case, is that you're asking questions to find out information. And his purpose was to find out if his supervisor would either get disciplined, terminated, or go to some sort of training, because he felt if that was him in the position, that would happen to him. But that because it was a supervisor, it wasn't. So is he even, you know, trying to say something is wrong there? Or is he really saying, well, I'm an employee and you treat me different than a supervisor? You know, you really have to look at the context of what he said under those both conversations, and in both conversations, he wasn't bringing anything to the attention of anyone that should be investigated, because he wasn't bringing any detail, any new information, anything that would be new or unknown to his supervisor, to Saginaw County 911. So we would ask that this court affirm the trial court and the Court of Appeals, and I'm happy to answer any questions.
Any additional questions?
Thank you.
Thank you
Your
both.
Honors.
The case will be submitted. The court will recess until 1 o'clock.